Namaskar, I am Assistant Professor Kritika Dev from LJ School of Law, and today we'll be dealing with part 2 of burden of proof. As I mentioned in my previous lecture, that is this particular topic, burden of proof, is being divided into two parts. We have already taken the first part, and today is the time for the second part. So let's quickly move on to the sections. So here section 107, we read till section 106 in the previous lecture. Now let's see what section 107 is trying to say. Burden of proving death of person known to have been alive within 30 years. Now this is a section which says that burden of proving the death of a person known to have been alive within 30 years. So the question is whether a man is dead or alive. Now the question is what? Whether the man is dead or alive, and if it is shown that he was alive within 30 years. Right? The question is whether a man, for say A is alive or dead. And it is shown by other evidences that he had been alive since 30 years. That when it comes to within 30 years, people have seen him somewhere that he was alive. Now the burden of proving that he's dead is on the person who says that he's not alive. Are you getting my point? The point is there is a question whether A is alive or dead. Now it is shown by other people or by other evidences that people have seen him alive within 30 years. So within 30 years, he had been seen alive by some people. Now, if somebody says that no, he's dead, then the burden of proof is on the person who says that he's dead. I hope you got this very point, right? So it is whether he's alive or dead, and he has been, now the points to be kept in mind is, the question is whether A is alive or dead, right? And it is shown that within 30 years, he has been seen alive. Within 30 years, the time period is 30 years. Now, the burden of proof that he is dead, if somebody now asserts that no, he is dead, now the burden of proof lies on that very person to show that he is dead. Now he can show it through any of the evidences, right? So this is section 107. Now, the next question is burden of proving that person is alive who has not been heard of for 7 years, right? Here again, the question is whether a person is alive or dead. The same question. But here, it is shown that nobody has heard about him, people who generally would have heard about him since 7 years. The question is whether he is alive or dead, and it is shown that in 7 years nobody has heard about him. So now burden of proof is on the person who affirms that he is alive, right? Because when it comes to he being alive, nobody who actually would have known about him has no idea since 7 years. Nobody has any idea since 7 years whether he is alive or dead, right? And now some person says no, he's alive. So the burden of proof is on the person who affirms that he is alive. This is all about section 108. Now let's see what section 109 tries to say. Burden of proof as to relationship in cases of partners, landlords, and tenants, principal and agent. So here you can see there are these relationships, and if there is a relationship like this, the partnership first of all, if it is shown that two people, through the evidence of course, it has been shown that two people are the partners, they are under the partnership, right? Then the burden of proof is on the person who affirms or who says that no, they are not under partnership. The question is whether two people are partners or not, and it is shown through the other evidences that they are partners. Now, the burden of proof is on the person who affirms that no, they are not partners. Have you got my point? So, it is on the person who says that no, they are not partners. The third situation under the same section is landlord and tenant. Now, for say, if two people, generally it is a tradition in India, whenever a landlord goes, and if at all there is a tenant, in the same function, he'll always introduce that person as the tenant. That meet my tenant, he's my tenant or she's my tenant, right? So if the question is whether the two people are related with the relationship of a landlord and a tenant, and it is shown by the help of the other evidences that they are the landlord and the tenants. Now the burden of proof is on the person who says that no, they are not the landlord and tenants, they are not in that relation, right? The same applies to principal and agent also. The burden of proof will lie on the person who says that no, they are not in the relationship of a principal and an agent, right? Okay, now there is section 110 that talks about burden of proof as to ownership. Now, what this section tries to say is when the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. Now, here let's take an example. A has a property of which he has the possession. A is having the possession of a property. Now, here B says that no, he is not the owner, I am the real owner, or anybody XYZ is the real owner, right? So here, because A is having the possession of the property, right? The first thing is he has the possession, and it has been shown. It has been proved to the court that he has the possession of the property. Now, burden of proving that here A is not the owner of the property is on the person, maybe here in this case on B, to who is asserting that no, he is not the owner, though he is in possession, but he is not the owner, right? So burden of proof is on him because here A is having the possession. So in as a general rule, it has been said that generally, if we leave tenants and everything, the person who is in possession is the owner, right? So here, in order to prove that the person who is in possession is not the owner, the burden of proof is on the person, here in this case on B, that A is not the owner of the property, right? So that is all about section 110. Now here the section 111, that is 111, is proof of good faith in transactions where one party is in a relationship of active confidence. Now here, if there is a transaction between two parties and one party is in a position of active confidence, right, then burden of proving that the transaction was made in good faith is on the party who is in the upper level, who is in the dominating position, who is in the position of active confidence, right? So let's see certain examples. For say there had been a contract between a child and a parent, both of course major, but of course parent any day has an upper hand. But in the same case, if a parent is really old, then the child gets the upper hand, right? It differs from case to case. Doctor and patient, here of course doctor has the upper hand. So when it comes to any contract between these two, between this relation, then they have been considered as the relation where the other party has the upper hand, has the active confident, has the dominant position here. Guardian and ward, solicitor and client, spiritual advisor and disciple. So here in this, one party, as you can see, is in a position to dominate the other. So when it comes to any transaction between, this is just an example which are the result of many of the case laws. So when it comes to these parties, then and a transaction has taken place, then the burden of proof as to the good faith in the transaction, that the transaction was made in a good faith, is on the party who is having the dominant position, right? So the party has to prove that it was a transaction in good faith. So with this, I guess we are completely clear with what burden of proof is. Of course, it took two different sessions, but now you must be very clear about all these sections in detail and what burden of proof is actually, right? With this, I would like to rest my lecture. And as I always say, after the lecture, kindly revise, keep your books open, and yes, it is actually very important that you revise it again after my lecture, right? And of course, it will give you the connection till the very next lecture. So till then, keep studying, and thank you so much for listening.